This is a CBSN Pittsburgh special presentation.
Hi, I'm John Delano, Money and Politics Editor at KDKA Television, CBS Pittsburgh. And our very special guest is Patrick Nightingale, who is a prominent criminal defense attorney right here in Pittsburgh, and also a medical cannabis advocate of many, many years. Patrick, it's always good to be with you, sir. Thank you for talking to me today.
John, thank you very much for having me on. And as we're going to be discussing, the Pennsylvania Supreme Court just handed down a pretty, significant decision yesterday when it comes to issues of probable cause and search and seizure.
Well, that, of course, is what I want to ask you about. And before we get into the details, let me just ask the basic question. What's your reaction to the decision of the Supreme Court?
My reaction is that it is the right decision that they made, because we have medical marijuana in Pennsylvania right now. It is 100% legal. And the medical marijuana that we have available in Pennsylvania also includes medical marijuana that has a strong odor of cannabis. And the Barr decision says that because we have legal medical marijuana, the mere odor alone is not sufficient to establish probable cause to search for an illegal item, because we do know that it is legal and that hundreds of thousands of Pennsylvanians are legally using it.
I want to get into the details of that case in just a few minutes and the decision, but let me first start with basics, because if I understand correctly, this was two individuals were driving in a vehicle and they were stopped without a warrant. So maybe you could help us understand, in the United States, both in the US Constitution and in the Pennsylvania Constitution, citizens are protected against warrantless stops. What exactly does that mean?
Well, under the Fourth Amendment and Article 1, Section 8 of the Pennsylvania Constitution, citizens cannot be stopped or searched without probable cause. And what that generally requires is that in order to search somebody, law enforcement must have a search warrant supported by an affidavit of probable cause. So if a police officer came to your house and wanted to search it, and you said, no, I'm not going to let you search the house, and the officer says, well, we have probable cause to believe that you have, an illegal marijuana grow in your attic. We're going to go get a search warrant. The judge is going to sign it, and then we can come and legally search your house. Now, there are certain exceptions to the warrant requirement. And the exception that is relevant here is what's called the plain view exception and its corollary, which is the plain smell exception. And what those exceptions say is that if an officer sees an item that its illegal nature is immediately apparent to that officer, or the corollary, the plain smell doctrine, if that officer smells something and it is immediately apparent to that officer that that smell is related to an illegal substance or an illegal item, then that officer can conduct a warrantless search. So in the scenario that I just explained, the officer comes to your house, knocks on the door, you open the door and you say, no, I'm not going to let you search the house. But the officer looks over your shoulder and sees what is immediately apparent to be rocks of crack cocaine and a crack pipe. Can that officer then warrantlessly enter your residence and seize those items? Yes, under those circumstances, the plain view exception allows the officer to conduct that warrantless search.
Gotcha.
And the corollary, the plain smell exception, is what is at issue in Commonwealth versus Barr. Because what happened in that case is it was a lawful traffic stop, but when the police approached the vehicle, the trooper testified that they smelled an odor of marijuana coming from the vehicle. Mr. Barr was a medical cannabis patient, but the police nonetheless, based solely on the odor of cannabis, searched the vehicle and then found a firearm and arrested Mr. Barr for illegal possession of the firearm.
Ultimately, what the Supreme Court held, though, was that the trial court was correct in suppressing that evidence, meaning that because the troopers had no right to conduct a warrantless search, that evidence could not be used against Mr. Barr?
That is correct. And it is based on a Supreme Court case called Commonwealth versus Hicks. And Commonwealth versus Hicks relates to concealed carry of a firearm. And what the Supreme Court said in Commonwealth versus Hicks is that because individuals in Pennsylvania can lawfully carry firearms with a concealed carry permit, merely seeing a concealed firearm is not probable cause to arrest that individual, seize the firearm, and to go on with that type of warrantless seizure. And what the trial court in Barr did was say, we're analogizing Hicks and concealed carry to medical marijuana, that because Pennsylvania has lawful medical marijuana, just like Pennsylvania has lawful concealed carry, then the mere odor of marijuana without more cannot establish probable cause for the warrantless search of the vehicle, just as an individual carrying a concealed firearm without that officer saying, wait a minute, I know Joe Smith has a felony conviction, so I know that he's not lawfully permitted to carry that firearm. But just because that firearm is observed to be in a concealed carry, being carried concealed by an individual, is not probable cause. The same as the odor of marijuana, because it's legal for hundreds of thousands of Pennsylvanians to possess and use, cannot establish probable cause.
Let me ask you a little bit about the science here, because I think a lot of folks might be surprised to know that medical cannabis has an odor like the marijuana that you might smoke. Can you describe, is that the case? I mean, does medical cannabis have an odor?
Absolutely. The flower buds, the flower material, the nugs, that which we're familiar with, the green leafy vegetable matter, that has been legal to purchase in our medical marijuana dispensaries since August of 2018. And what gives marijuana, what gives cannabis, what gives that flower its unique odor is not the presence of THC or other cannabinoids. It's the presence of what are called plant terpenes. And these are botanical oils found throughout the plant kingdom. And it's also found in medical marijuana and varying strains of marijuana. For example, there's a terpene called linalool that is found in marijuana, and it's associated with having a sedative or anti-anxiety medical effect. And it's also found in lavender. And there are other terpenes. Pinene is what makes pine trees smell like pine. It's also found in cannabis. Beta-caryophyllene is what makes pepper smell like pepper. It's found in cannabis. Limonene makes citrus smell like citrus. It's also found in cannabis. And what we have found through years of research is that it's these plant terpenes which really distinguishes one strain of marijuana from another. And it's the presence of certain terpenes that patients look for to alleviate their conditions. I'm a patient. I suffer from general anxiety disorder and PTSD. For me, a strain that is high in a terpene such as linalool or myrcene is something that I look for, because those terpenes are associated with having an anti-anxiety and more sedative effect.
So when an officer or a trooper approaches your vehicle and they smell marijuana, what they think is marijuana, the new rule in Pennsylvania is they cannot stop you. They cannot conduct a search for that marijuana simply because medical marijuana is now legal?
That is correct. The odor is no longer per se probable cause to search. Now, I just put some of this information out on social media, and the first question I got was, well, what about DUI? Well, that changes the analysis a little bit, because while I, as a medical cannabis patient, am 100% legal to possess medical cannabis in the Commonwealth of Pennsylvania, I cannot operate a motor vehicle if I have either Delta-9 THC or any of its metabolites in my blood. So if a traffic stop occurs and the officer says, oh, Mr. Nightingale, I smell an odor of marijuana coming from your motor vehicle. And I say, you know what, officer, I'm a medical marijuana patient. Now that officer has reason to suspect that I will have either THC or carboxy THC, which is the non-psychoactive metabolite in my blood. And that can lead to a DUI investigation, separate and apart from the mere odor of cannabis.
Interestingly, in the Barr case, the individual who was using medical marijuana was asleep in the back seat. It was his partner who was doing the driving. So there was no question there that the driver was not under the influence, right?
Correct. It had nothing to do with the driver being suspected of DUI. But as soon as I talk about the odor of cannabis no longer being per se probable cause, the next question I get is, well, what about DUI? So I figured I'd throw that out there to our audience. And there's one other interesting wrinkle that this brings up. It was not part of the Barr case whatsoever, but it is specifically relative to the or relevant to the odor of cannabis. And that is the fact that hemp, which is defined as cannabis sativa L with a total THC percentage of 0.3% or less, is 100% legal pursuant to the Farm Bill of 2018. That's why if you go to a grocery store or if you go to a Sheetz, you see CBD products and other hemp-derived products that are available. What some hemp farmers are doing is they're producing hemp buds, hemp flower, the green leafy material with, very low THC. It cannot get you high, but with a terpene profile where you will have the same plant terpenes that you have in marijuana with a higher percentage of THC, thus giving legal hemp that exact same odor as either illegal marijuana or legal medical marijuana. So not only do we have legal medical marijuana, but now we have a very thriving industry in Pennsylvania of hemp farmers selling hemp buds to be consumed via smoking that can't get you high, but also have this terpene profile under the guise that, hey, you still get the medical efficacy from limonene or linalool or pinene or myrcene. You're just not using a product that has a psychoactive effect to it. The flowers smell exactly the same as what you would get in the dispensary or what you might get from your guy, on the street corner.
So what is your advice, finally, to both police and to users of marijuana? So let's start with the police. What is your advice to the police when they suspect marijuana use, which is still illegal if it's not medical marijuana, right?
Correct. First and foremost, if you're engaging in a traffic stop and you detect an odor of marijuana coming from the vehicle, you've got to be aware of the fact that, number one, it could be legal medical marijuana if a patient is in the vehicle, or number two, that odor could be from legal hemp. So educating law enforcement on the current state of the law and the current state of what is actually legal in Pennsylvania and what causes this odor from marijuana is very important, because they no longer can simply say, I smell it, so therefore it's illegal. So educating law enforcement, making sure that they're aware of what the Farm Bill of 2018 makes legal, making sure that they're aware that, yes, very strong smelling marijuana can be legal medical marijuana, legally and lawfully purchased in a Pennsylvania dispensary. So, just as from the very beginning of our medical marijuana program, law enforcement education, I think, is critical on this issue.
So that smell alone is not sufficient. If they think someone's driving erratically, and therefore there's a potential of driving under the influence, that's different.
That's correct, because what the Supreme Court said, and the Superior Court and the trial court, they all said that the odor of cannabis is not per se. However, there can be other factors that, when considered, can establish probable cause. And for a DUI scenario, an odor of marijuana, erratic driving, perhaps an admission by the motorist of recent cannabis use, that most certainly are those additional factors that the Supreme Court is contemplating that could establish probable cause.
Finally, Patrick, what's your advice to cannabis users, both legal and illegal?
Do not transport cannabis. If you are an illegal user of cannabis, don't drive around with a quantity of cannabis in your motor vehicle. What I have told medical patients that what they want to do is everything they can to prevent a law enforcement encounter during a traffic stop. Make sure your vehicle is in proper working order. do not commit any traffic violations. And if you are transporting medical cannabis, one, it has to be in its original dispensary packaging. A lot of patients don't understand that they cannot take, flour from the dispensary packaging and maybe put it in a Ziploc bag like they've always done so before. And then take that original dispensary packaging and put it inside a mason jar or some other smell-proof container. So there's no possibility whatsoever. And the reason I give this advice is under current DUI law, a medical cannabis patient can be arrested, prosecuted, and convicted for DUI with no proof of impairment whatsoever, based solely on the presence of non-psychoactive THC metabolites. Law enforcement knows this. So what I have seen, unfortunately, is that medical cannabis patients who openly admit that they're a patient during a traffic stop now find themselves subject to a DUI investigation, being asked to take a chemical test. And if that chemical test reveals non-psychoactive carboxy THC in their blood, they're getting charged with DUI. And that's something that's being addressed on appeal before the Superior Court right now. That's something that's pending in the legislature. But as it exists right now, for legal medical cannabis patients, you are DUI 24/7, 365, regardless of whether or not you have any active Delta-9 THC in your blood.
So that suggests, Patrick, that if you are using medical marijuana, you ought not to drive.
It suggests that entirely. And I do not believe that that was the intent of the General Assembly, to strip 400,000 Pennsylvanians, that's how many we have in our program right now, of their ability to operate a motor vehicle without proof of impairment. Now, without a doubt, absolutely no one, either a legal medical marijuana user, a marijuana user in a legal adult use state, or an illegal user, should never, ever operate a motor vehicle while impaired by cannabis. The issue that we have is that Pennsylvania DUI law allows the Commonwealth to obtain a conviction with no proof of impairment whatsoever, and that needs to change.
That sounds like the next Supreme Court case we're going to hear about.
It may very well be, because Commonwealth versus Stone was just argued before the Superior Court. And in Commonwealth versus Stone, the issue was whether or not medical marijuana is a Schedule I controlled substance under the vehicle code, just like illegal marijuana is. And Commonwealth versus Jesse, a case that I argued before the Superior Court a couple of years ago, the Superior Court said that if marijuana is medical marijuana pursuant to the Act, then it is not scheduled pursuant to Pennsylvania's Controlled Substances Act. If it's not a controlled substance, then this zero tolerance DUI goes away. So we'll have to see what's coming up when the Superior Court rules on this.
Well, criminal defense attorney Patrick Nightingale, one of the best in Pittsburgh and certainly an expert on the issue of cannabis. Thank you, sir, very much for spending so much time and helping us to understand this. I really appreciate it.
Hey, it's my absolute pleasure. I'm here as a resource for you, and to you and your listening audience, Happy New Year.
This has been a CBSN Pittsburgh special presentation. We now return to our scheduled programming in progress.